Tableau 10, From Poles to Bombs. Part 2, The Poisson flits in. We have seen how the binomial distribution arises naturally in the context of poles and polling systems. And we shall return to this. But today we shall take a small detour through an accidental discovery of Simeon Denis Poisson in the year 1837. And this discovery was to have subtle and deep consequences. Along the way, we shall discover the Poisson distribution, which, together with the binomial distribution and the normal distribution, constitute the triad of fundamental distributions in the theory of probability. The context is historical and rich, and the setting is that of judicial trials and, in particular, trials by jury. Listeners of a particular age would be familiar with the evocative image of an Atticus defending his client in To Kill a Mockingbird before a bank of jurors who are deeply skeptical. The principle of trial by jury is fundamental to democratic institutions, and in the United States in particular, in felony trials, it was standard for many, many years to have a jury of 12 individuals. In the year 1970, in the case Williams versus the state of Florida, this principle was challenged. Florida had reduced the number of jurors from 12 to 6 in a particular felony case. Williams challenged it, and a bitterly divided Supreme Court ruled that a decrease in size of jury from 12 to 6 did not contravene the constitutional protections of the rights of the accused to an impartial jury. The constitutional connection that is alluded to is the Sixth Amendment to the United States Constitution, which guarantees individuals a right to a speedy, public trial with an impartial jury. Justice White opined for the majority in that case that there was nothing sacrosanct about the number of the jury. So, as I said, a bitterly divided court. In the majority, they opined that the function of the jury was to exercise common sense judgment in the complaint between the plaintiff and the defendant, but that the size of the jury did not affect the quality of this judgment. After this judgment, a variety of critiques came up, and several further judgments were made as well. But as late as 1979, the court reaffirmed his position. This time, Justice Rehnquist, writing on behalf of the majority, opined again that a jury of size 12 was in no way more reliable in terms of the quality of the decision-making than a jury of size 6. It is not clear what statistical or mathematical references the court was using, if any, at that time. But a fundamental question surely arises. Now, I surely do not want to get into the niceties of the legal arguments here or of what the Constitution actually says. We are treading very close to the limits of my knowledge on this subject. But as a citizen, it is clear that we need functioning juries to give us justice. And a fundamental question then arises: what principles, mathematical principles, logical principles, societal principles should govern the size of a jury? Now, the nearest antecedent to this in history was about 200 years ago in late 18th century France. And these questions about democracy and juries and trials were bubbling and coming to a heated conclusion. Of course, this was going to be the time of the French Revolution, but A noted philosopher, mathematician, and political scientist at that time was Nicolas Marquis de Condorcet. And Condorcet wrote extensively on the subject. In 1785, for instance, he published what is today called Condorcet's jury theorem, in which he articulated the following principle: that if in a voting group, a jury, each member is more likely than not to make a correct decision, then the probability that the majority vote yields the right decision increases as the group size becomes larger. Now, I don't want to take a detour to try to prove this, though it is not at all hard, right? And if the listener will spend a couple of minutes thinking about what it'll take when you add two new members to a jury to improve the decision, well, either both could be right or both could be wrong. If they split the decision, then clearly nothing has changed. But if each slightly favors the correct decision over an incorrect decision, then the chance of both getting it right is going to exceed the chance of both getting it wrong. And that is all there is to it. Of course, there is a flip side to this coin, and that is that if one has an uninformed jury, a collection of peers whose decision-making is suspect and who are likely more than half the time to come up with an incorrect decision, then the optimal jury size is 1. A larger jury only makes things worse. Already in 1785, the issues of jury size and selection were becoming important, and deep thinkers were articulating essential principles behind these ideas. Now, Condorcet was acutely alive to the fact that when juries make errors, they could make errors in one of two directions. And this was picked up and articulated by Pierre-Simon Marquis de Laplace in 1820. We are familiar with Laplace. We have seen Laplace, his ideas arise in his law of succession, in his book on probability in the year 1812. Laplace was also deeply interested in societal issues, and he weighed in on the jury selection issue. In particular, he articulated a risk principle which laid out the essential difference between the two different kinds of errors that are possible. So, if a jury makes an error, it could be in these two flavors. They could convict an innocent person, or they could acquit a guilty person. And Laplace was very clear in his view that the costs to society were not the same for the two kinds of errors. If one looks at Laplace's positioning of the problem, he seems to be suggesting that the societal cost is higher if one acquits a guilty person, presumably to go on and commit other heinous crimes, than it is to convict an innocent person. And clearly, already here, fundamental questions about democratic institutions are arising. In which direction should we offer more protection? Fundamentally here now are two questions. Given a jury size and a conviction threshold, remember the vote typically is going to be by a majority vote, what is the probability that a guilty person is acquitted? Under these conditions, what is the probability that an innocent person is convicted? Laplace, naturally enough, given his ideas on probability, put together a chance mechanism to try to model the setting. He modeled juror responses as essentially chance-driven, but he viewed the intrinsic guilt or innocence of the defendant as a pure chance variable equally likely to be one or the other. This created issues and complications, and this was picked upon by Poisson. We shall come to Poisson's model next.